We throw the word trust around all the time, right? We trust our friends, we trust our family. But what if I told you that sometimes that trust isn't just a feeling, it's actually backed by the full force of the law? Today, we're diving into this fascinating idea of fiduciary duty, which is basically when trust becomes legally binding.
And that's really the big question we're tackling. When does a simple promise, hey, I'll look out for you, cross the line and become something a court can actually enforce? It's a tricky area, but it's so important. So when does the law step in and say, nope, you have to put them first? Let's get into it.
Okay, so to really get our heads around this, we have to talk about the main character in this story, the fiduciary. Now, the word itself sounds kind of stuffy and complicated, I know, but the idea behind it is actually super simple. It's all about one person guarding another's interests. At its heart, a fiduciary relationship is a formal relationship of trust. You have one person, the fiduciary, who agrees to act in the absolute best interest of another person, called the principal. Think of them as the legal guardian of your interests. And this is the important part. Their own self-interest has to take a back seat. The principal's well-being is everything.
So what does acting in their best interest actually look like? Well, it usually boils down to three big rules. First, the duty of loyalty. This one's huge. It means no conflicts of interest, no self-dealing. The principal's interests come first, period. Then there's the duty of care, which means they can't be lazy or sloppy. They have to be competent and act as any reasonable person would in their shoes. And finally, the duty of good faith. They have to be honest and upfront in everything they do. No sneaky business.
Okay, that all sounds great in a textbook, but how do you prove it? That's the million-dollar question, right? Especially when there's no contract with the word fiduciary written in big, bold letters. How do judges actually decide if this powerful obligation is really there? Well, to figure that out, we've got to look at a real case.
And for that, we're going to hop in a time machine back to 1990 to a landmark case called Hill v. Rose. This case is a huge deal because it gave courts a super clear roadmap for spotting these relationships out in the wild, even when they're not obvious.
So here was the setup. On one side, you had a guy named Hill. He put a ton of trust in his business partner for a really important project. On the other side was Rose, who basically said, yeah, I'll handle it, and took on the responsibility to act for Hill. Now, because of that arrangement, Rose had all the power over Hill's financial interests. And that power imbalance, that's the key.
So when this whole thing ended up in court, the judges did something that really changed the game. They didn't just search for a piece of paper that said fiduciary. Nope. They looked at the relationship itself, how these two people actually interacted, and what they figured out became a cornerstone of law.
The court laid out this brilliant common-sense three-part test. First, they ask, is one person especially vulnerable here, kind of at the mercy of the other person? Second, did the other person voluntarily agree to act for them, to take on that responsibility? And third, does that agreement give them significant power to impact the other person's interests for good or for bad? If you can check all three of those boxes, then bingo, you're probably looking at a fiduciary duty.
And this is the most important thing to get. A fiduciary duty doesn't come from a job title. It's not about being called a consultant or a partner. It comes from the situation itself. It's all about that dynamic of vulnerability, responsibility, and power. The substance of the relationship is what the law really cares about.
So you might be thinking, okay, cool story about a court case from 1990. Why should I care today? Well, here's why it's so incredibly relevant. That principle, that the relationship defines the duty, means that these fiduciaries are literally everywhere. We interact with them all the time.
I mean, really think about it. The financial advisor who manages your retirement fund, yep, they have a fiduciary duty to put your financial success ahead of their own commissions. The real estate agent selling your house, they're legally required to get the best possible deal for you, not for themselves or the buyer. Lawyers, trustees who manage a will, even members of a company's board of directors, they all operate under this incredibly high standard of trust.
This quote just nails it, doesn't it? It says, the fiduciary principle is the law's way of enforcing loyalty and trust where it matters most. It ensures that power isn't abused. That's what this is all about. It's not some dusty legal concept. It's the law's best tool for protecting people and making sure power isn't taken advantage of.
So if you walk away with one thing today, let it be this. Trust can have real legal teeth. And it really makes you stop and think, doesn't it? Who are the people in your life that you've given power over your interests, your money, your property, your business? Just recognizing that relationship is the very first step in making sure that your trust is truly protected.